Good evening, friends. So this side, Rahul Magan here is Group Chief Executive Officer Treasury Consulting, which is a Singaporean multinational headquartered group, and very soon we would be having British headquarter group as a title. Today is a very interesting day. We have Brexit and it's around 3 a.m. in the morning, and probably one and a half hours after that I am awake definitely. 1.5 hours from that, Boris Johnson will come from 10 Downing Street, London, and he would officially be announcing the Brexit. So effective tomorrow, which is 1st February, and it is already 1st February in India and probably in Singapore also. And effective one and a half hours, London would officially be out of European Union. So in a day or so, a lot of things would come, and we need to read this carefully as we are planning for a British entity in April. So a very good and in fact interesting times ahead. I have never thought that I would be watching Brexit so closely, because now it is my own commercial interest. That's one thing. But today we're not going to discuss about Brexit. Rather, we're going to discuss about something a topic which is very hot actually. A topic which I think no corporate in the world can live without that topic, to be honest. And Treasury Consulting is now foraying into this topic. You know our competence, you know that how we scrutinize the things. And this topic is nothing but arbitration. Majority of the contracts which are written in the world do not have an appropriate arbitration clause. Even if it do, then it is only for the sake of the name. Henceforth, in case of any official dispute, the person who gives the work, the person who takes the work, both are either out of option, and in most of the cases the person who gives the work is out of option, to be honest. Arbitration is nothing but an act whereby both the parties, because it's of three types actually. Although there are multiple kind of arbitration, like the simplest form of arbitration is that two companies decide a common person in between who try and resolve the problem. That's the simplest form of arbitration. Second form of arbitration is that both the parties have their independent arbitrator. That is also not incorrect, because if big companies, for example like ExxonMobil, which is an oil giant, is in dispute with British Petroleum for some issue, then rather than have a common arbitrator, they wanted to have independent arbitrators who will focus on their interest. Like ExxonMobil arbitrator will have an ExxonMobil interest, and so as the British Petroleum. Well, third case is that we have three arbitrator model. Now the three arbitrator model is that we have two arbitrators and one final arbitrator who will take a final call. So three arbitrator model is just like ExxonMobil have his own arbitrator, British Petroleum have his own arbitrator, and the third arbitrator assume this specs, and he will take a final call. He will hear both the parties, he will take the final call. The fourth kind of arbitrator is very rare and it is costly actually, and in which we have two arbitrators. We have a final arbitrator, but the final decision is to be taken care by a body of the local body, and in some cases an international body who manages that arbitration. But that is very costly. But that is easier said than done. The reason is that it's easy to say that arbitration, because majority of the contracts in the globe do not have arbitration clause mentioned in a rightful way, including ISTA. If you look at ISTA, International Swap and Derivative Association, the leading body of ISTA, you would get to know they do not have a sufficient way, or the sufficient way of mentioning the arbitration. I think it's very shallow in ISTA Master Service Agreement. In fact, in Risk Disclosure Statement, which is shortly known as RDS, they have not mentioned it completely, to be honest. But the problem of the arbitration do not end here, rather the problem starts from here. I have deep respect for Singapore. There's no doubt about that, and everyone know that. That's the reason we have made Singapore as a global headquarter, but due to some issues now we are moving to London. because London financial market is big and conducive. Of course, Singapore is too, but London is better. Singapore is termed as the number one place as far as the arbitration is concerned. And it is said that Singapore judiciary is a very nice and honest judiciary. I have never tested, so I don't know. This is what it said. When it comes to arbitration, there are multiple forms of arbitration. Example, real estate arbitration, constructions arbitration, banking arbitration, finance arbitration, and multiple. But the problem starts from here. The problem starts from here. Number one, it is just like, I don't know, how should I say, it is like a kind of game in which there are so many characters, and even the director of that game or the producer of that game do not know who is who. In Singapore, we have a body called SIAC, which is Singapore International Arbitration Center, SIAC. I'm not saying they are the only body, they have multiple bodies pertaining to arbitration, but they are the leading body. Like we have a Law Society of Singapore also. Singapore International Arbitration Center or the Singaporean arbitration guidelines are having multiple technical issues. And I assure you, in the next 2 months, all these technical issues will come in public domain and we're going to deliberate on that I assure you. Because definitely on our YouTube channel is not to discuss about any corporate or any media house, we discuss about the facts. And because we're not worried, we don't have a million plus viewers, who cares? Because we know we are giving our knowledge to the people, to those people who wanted to have the knowledge. Because we don't talk IRR, internal rate of return, XIRR, NPV and all. We talk about multiple things, right? The biggest problem with the Singapore arbitration is that when it comes to the banking arbitration, the clear-cut demarcation is not given, which creates confusion. Example, you must be thinking that why there is a demarcation required in the banking arbitration. And by the way, soon we're going to have soon Treasury Consulting would be introducing number of concepts just like technological arbitration. Guys, do you know that arbitration is changing at a very faster pace? Because today you have artificial intelligence, machine learning, virtual reality, augmented reality, and hell lot of stuff. And the arbitration guidelines which were designed long ago, they were not accustomed to that. But anyways, we cannot cover the whole world of arbitration in 10-25 minutes video. We got to cover one by one. According to me, the biggest problem in the Singaporean arbitration laws is that the banking arbitration should be divided into 2 parts. And don't worry, if Singapore not did that, we got to get this done. Rest assured. We are coming up with our arbitration desk, and that would be live on our fixedincome.global, and we challenged all the law firms of the globe, including Singapore, as far as their arbitration is concerned. Rest assured. Now, according to me, the banking arbitration should be divided into 2 parts. And if you are thinking that we only talk about banking arbitration, then hold, we go to cover everything. Give us some time. This is our first video of arbitration. According to me, banking arbitration should be divided into 2 parts. One is banking arbitration having technological part and banking arbitration without technological part. Banking arbitration with technological part should be divided into 2 parts. Involvement of any CCP, non-involvement of any CCP. CCP stands for Central Clearing Counterparty. Just like SGX, CME, list is long. LCH, CLS, very long. Non-bank, bank with non-technology is straight. And the bifurcation go long. Example. Today, I am hiring an artificial intelligence company. I am not quoting any name. And I wanted to create a robo-advisory. I do not need to tell you what is robo-advisory, right? A robo decides the portfolio, earns an interest, it's all automatic. Till what extent we surely going to cover soon. What happened? The model the person made on that robo via artificial intelligence, this is having a technical error. In fact, two technical errors. The first technical error is it takes VAR, value at risk, that is dead. The right answer is expected shortfall, ES. And more importantly, rather than taking imputed volatility, it do take historical volatility. Due to these issues, the alpha factor, the model capability to generate alpha factor reduced by 35 bips. I'm just taking hypothetical example. So the company not been able to earn the 35 bips, so they not been able to pass to the customer. They lost AUM, asset under management, and they take hell lot of time to be at the break even. Later, after 5 years, the contract is valid between the person who developed that robo-advisory and the company who gave the work. The contract is still valid, although AMC, annual maintenance contracts. This company got to know about the mistake in the coding, and this company challenged that company who made the model that every month we lost 35 bips, 35 into 12, approximately 3.6%, roughly 3.8%. So you need to pay us 3.8 into 5, which is practically around 16-17% into whatever AUM. And the company who made the bot, the robo, they immediately enter into the arbitration mode. They're saying, no way, forget 15%, we will not get to pay, we will not pay you 15 cents. According to the present guidelines of Singapore, Singaporean international by multiple bodies, it do not cover such form of arbitration holistically. Now in arbitration there is a word called holistically. Holistically means that, holistically doesn't mean the in English vernacular word. Holistically means that everything around that should be covered. How would you cover that? How would you cover that? Because the contract you have designed, you not mention artificial intelligence based arbitration. You have not mentioned the code of conduct. You have not mentioned the kind of a model you are looking for. You have not specifically mentioned the dispute arising because of the delta factor. And this problem will aggregate more in arbitration if I add front office and the SWIFT into this. But if this kind of product would have a SWIFT connection with the SWIFT network, Society for Worldwide Interbank Financial Transaction, and the front office piece where we have Reuters and Bloomberg, MT4, MT5, ECNs and whatnot. SIAC or the Singapore arbitration guidelines do not cover that holistically. I am not saying that Singapore arbitration guidelines is incorrect. They are perfectly correct. But having said that, Singaporean arbitration guidelines are having multiple flaws. And due to these multiple flaws, there are multiple interpretation issues that come into the picture. And when it comes to the banking arbitration, these flaws are getting extravagant, or maybe in some cases the gap between an ideal situation and where are we is much wider, just like a glacier. So to cut the long discussion short, arbitration is a very important thing. Arbitration is an integral part of life. No contract can be written without a proper arbitration, but unfortunately the contract like ISDA, which is International Swaps and Derivative Association, do not have the right way of forming the contract as far as the arbitration is concerned. If you don't trust me, please visit only 4 documents of ISDA. One is ISDA Master Service Agreement 2005, one is RDS Risk Disclosure Statement, one is CSA, which is Credit Support Annex, some people mention CSX, and one is Schedule to Annexure. I repeat, ISDA Master Service Agreement 2005, Risk Disclosure Statement, CSA, which is Credit Support Annex, and one is the Schedule to Annexure. Please visit that and just read the arbitration guideline. You would get to know there is a hell lot of catch in the arbitration guidelines. And Singaporean arbitration guidelines is also not well proofed, which is shortly known as POC, Proof of Concept. This is our first video on the arbitration. We assure you the way we started our journey in 2014 via launching the first video, which is on fair value hedging. We assure you that there are multiple arbitration videos on the card. Treasury Consulting assure all the subscribers, all the readers that we are coming up with a complete full-fledged arbitration desk, which includes the technological part in it. We try and cover all part of technology, which is artificial intelligence, virtual reality, augmented reality, machine learning, bots, chatbots and whatnot. We assure you that. And more importantly, Treasury Consulting having a lot of stuff to offer in the arbitration, that is our insurance. And in the next 90 days, which is probably February, March and April, by 30th or 31st, whatever April, you would have a lot of data about arbitration in the public domain on our arbitration desk. We assure you that before the first half of the June would end up, as and when we start with the 1st of July, we would be a leading player in the arbitration, and we are going to be challenging the leading countries of the arbitration because there are flaws. Because unfortunately what happened, we tend to feel that no one is challenging them, it means nothing wrong. But the fact of the matter is there is a lot of things. Like this book is about Goldman Sachs, and I read this book, but there are a lot of things mentioned about Goldman Sachs which is not correct. I personally know Goldman Sachs very well. And everyone know the role Goldman played in my life, right? And they're still playing. There are a lot of things mentioned in this book which is not correct as far as the Goldman is concerned. But it is not mentioned even. In fact, the author not mentioned that. So if you believe that, if you do not know Goldman holistically, you do not know how they operate, how they work and all, if you read this book and tend to make a mindset that everything whatever the author mentioned is correct, or it is the only thing about the Goldman, then it is not. It is not. Like today, on Bloomberg, an author tried to compare Goldman with the Deutsche Bank. All Goldman and Deutsche are completely in different bank. The architectural design of Goldman is completely different than any other bank of the globe. Goldman cannot even compare with JP Morgan Chase. Forget comparing it with DB. They have different architectural design, and JP Morgan is successful in their architectural design. Goldman is successful in their architectural design. Both are successful. With this, we thank you very much. There is a hell lot of action to be happen on the arbitration front this year. We are heading as a bank, because by September we would be starting the beta testing. And we believe that digital banking is not about credit card and debit card. It covers everything. So, a lot of action on the card. You know my mobile number, which is +91 9899242978. I have an alternate number also, which is 9818485155. Our fixed income platform, www.fixedincome.global. Have a great time.